All right, Mr. Tramarko?
We talk about the planning board and what powers it has, and obviously you have to construe the ordinance the way it's written. But look how many variances you do grant every time you do a subdivision. You grant area variances, you grant frontage variances, you grant all of that. So you do have the power, even though we don't have a specific clause in there which would have made everybody's life a lot easier. You know, the application was started months before, and John Zolo was told, hold off because we're changing the ordinance. So we're not in this position because of a lack of something that I didn't do or John didn't do. We're in this position because the planning board told them, planning department, excuse me, this is what you should do. And, you know, oftentimes I, as much as anybody else, rely on what they say. Sometimes it works out, sometimes it doesn't. So I guess the only thing we can do in the future is document everything by letter, no matter what it is. You said this, okay. But, you know, we don't do that, and maybe that's our fault. But I think that you do have the power. Otherwise, why would the town board entrust this whole development rights to you and not give it to the Board of Zoning Appeals, who apparently has more expertise than you do? Thank you.
Yes.
My position was predicated upon 323.
Yes, would you use the mic, please?
The opinion I gave the board was based upon section 323.10, which is entitled the Rules for Transfer of Density Flow Rights. It prescribes our authority, in my opinion. And subdivision 4 provides, and I quote, density flow rights or portions thereof shall not be transferred to a parcel unless the yield for that parcel has been proven to the satisfaction of the planning board based upon a plan that complies with the zoning ordinance or for which a variance has been granted. I interpret it to mean that if we were presented with a lot which complies with the zoning for that particular area, 10,000 square feet, 20,000 square feet, or it had a variance from the ZBA, then we could deal with the question of developmental rights and not in other cases. And I think from Mr. Tramarko's statement that the parcel would appear to be less than the zoning for the immediate area leads us with only one conclusion, that it required a variance from the BZA. With reference to his last point, our ability to grant variances is prescribed only as it concerns subdivisions. We don't have any other right to grant variances. Thank you.
The section that you read, though, appears to pertain to the receiving parcel, not the sending parcel.
That's just what I was going to say.
But the way I read it, I mean, it says density, flow rights, or portions thereof shall not be transferred to a parcel unless the yield for that parcel has been proven to the satisfaction of the planning board, as you indicated, or for which a variance has been granted. So this appears to address the receiving parcel, not
Right.
the sending parcel. That's how I read it.
Mr. Schul. That's what it says. I mean, it probably messed up too, but
That's how I read it. It says this is it. Number 4 is talking about the receiving parcel. My opinion here, I think, is obviously a difference of opinion as to whether this board can address the single and separate issue. And I think that we might need something from the town attorney as to whether, when this ordinance was amended, not too long ago, they intended to give this board the power to make that determination.
Jim, could we like clarify that? Is it determining single and separate only when it pertains to TDRs? We can't make single and separate determination on subdivisions, could we? No. Or that isn't the intent here, is it?
Well, we're not talking about subdivisions. We're
No,
only
we're
talking
not.
about
That's what I
this
mean. We're only
particular
talking
section.
about TDRs, correct?
That's all. That's what this application is
Okay.
about.
That's correct.
Yes, it is.
And you're not usurping the Board of Zoning Appeals authority. That the application that we're dealing with and the one specifically before you is for TDRs. It's an application under Chapter 323. A couple of thoughts, and first of all, I don't like getting up here and he said, she said type of thing. I rely on the expertise and knowledge of the planning department, and I'm bothered. I don't want to stand here and point fingers, but the facts are, in this case, what happened, and everyone is learning on this application. I'm just sorry I'm the first case that's got to go before the board, and I get a parcel like this. But one of the things, and I thought about this, is perhaps if this Chapter 323 wasn't in place, we would go to the health department. And I feel very confident that the health department on this parcel would say yes. Since prior to 1980, it's a separate tax lot. It's been a separate tax lot forever. Mr. Machichi bought this parcel in 1967. Maybe to alleviate any problems for this board, you could cede authority to the health department. Let me just go directly to the health department and make application specifically on this parcel, and this board would waive jurisdiction on this case. That would alleviate you having to go to the town attorney for an opinion. It would just put this case to rest, and I can go where before Chapter 323 I would have gone and had this matter resolved.
John, I just want to tell you that's not going to be practical. And the reason it's not practical is because we entered into a contract with the county. If we decide to cede this, they're going to ask us a question. And I don't want to go down that path, okay? And I'm not going to discuss it with you, but I don't want to go down that path.
Mr. Zolo, just one last question. In your experience, or to your knowledge, as part of a determination to permit or not permit a transfer of density flow rights from one parcel to another, is a determination as to whether the sending parcel is in single and separate ownership a common or usual part of that determination?
I would say it would have to be, because the board has to make certain that a yield can come from that parcel.
This is a case of first impression. When we did it in the past, it was before the board, the health department. Health department didn't care about single and separate like the town does under their single and separate ordinance. So you go to the health department, you show that the two separate tax bills prior to 1980, bing, that's the end of it. They don't care if it's in the name of Adam Oshran and Adam Oshran, doesn't matter. It matters here because of the way the ordinance is written, for no other reason. And that's why John is suggesting, let's just go to the health department and stop all of this. But
Well, listen, we've got
Yeah,
all of this,
just-
we've got all of this documentation here. It's all gonna go to the council, to the board. And now what I want to know is what the board wants to do about how they want to report on this. So, would any of the board members here have any comments?
Excuse me, Mr. G, could I just make one more comment, and I will...
What?
Could I just make one more comment in response to what Mr. Earhart asked?
Okay, go ahead.
Just remember, single and separate issues come up in most cases. I would say this is a case of first impression, but single and separate issues is because someone wants to build a house on a piece of property.
Right.
What we want to do is we're sterilizing a piece of property. So we're making certain that no one can go to the Board of Zone Appeals for single and separate to put a house on this parcel. So they're serving a public purpose and a common good here by sterilizing this property so it's not developed with a house in the future, which I think if Mr. Tramarko's client went to the Board of Zoning Appeals, would be able to establish single and separate ownership on this parcel and build a house.
All right. I need some input from the board here now. Where do you want to go with this information that we've been given?
Well, I think we need to have some type of clarity when it comes to 323. I mean, what is our authority when it comes to dealing with TDRs in this particular instance of single and separate, or making the determination? How do we get a some clarity on our jurisdiction.
Councils?
I agree with that. I think preferably, I'd like to see what the town attorney has to say.
Clarify this?
Yeah. I don't know what everybody else.
I
Well,
would too.
I think we need, I don't know if it's been addressed already, why does it make a difference as to whether it's single and separate or not, in order for transfer development rights to go from the parcel to the parcel that's owned by the fire department? And two, if it has to be determined whether it's single and separate, does 323-7, because it gives us the authority to determine whether or not the density flow rights can be transferred, to also make the determination as to single and separate?
I think any interpretation of section 323 as made by the town attorney. Or the drafters of the statute, one or the other.
If there's any memorandum, or if there's any, these are the things somebody has
No
to look into.
McKinney's.
Huh?
There's no McKinney's, no.
Legislative history. So I think we need some kind of an opinion on whether or not we can hear the
Well,
single and separate issue.
we need it in a timely fashion because of whatever the contractual things are that I want to be able there to determine there where it's going to be done or not done. Is that understood?
And Jim, your point that you brought up, and is it a requirement of being single and separate in order to have a TDR?
Right.
Or are we going by Suffolk County Department of Health standards? I mean, what's the direction that we should go on this?
But the question that I have for the board is the timeliness of this. What do you want to do, and how long do you want to do it?
Immediately. It should be done immediately. It's not
Okay,
fair.
so that by the next meeting?
If there
I
could be
think,
some
yeah.
memorandum by the next meeting.
I don't know that we could dictate to whoever's going to give us the memo as to when they can give it, but I would just say as soon as is reasonably possible.
Well, what does the applicant do there with the timeline there of his contract?
Well, we're told by the attorney for the planning board that he doesn't think we have the authority to decide the issue. And I think
Okay.
it's an interpretation of the code section. I think the best person to give us an opinion on whether or not this code section intended for us to decide the single and separate issue is the town attorney.
And Jim, is it a necessity to be single and separate for a TDR?
Yeah, that's my question. I mean, I can understand why if someone's building on a piece of property, why that determination might be made. If you have a lot that's smaller than the minimum lot size and it pre-existed, but this is a different situation.
Can't answer your question this evening, but I could probably answer it by 10 o'clock tomorrow. You know,
Fine with me.
okay, so I'll inform the board by, I'll call the chairman first thing tomorrow morning after I speak with the town attorney, and I will, at the direction of the chairman, either call you or he will call you.
So we're going to find out within, I guess you're telling us within 24 hours on whether or not there is a requirement for single and separate.
No. How long it'll
No,
take
he's
the
gonna
town
go
attorney?
On the time frame, okay.
He's going
Thank
to go
you.
to the town
Thank
attorney
you. I was
with,
a little-
okay? Is that understood?
Yes.
Very good.
Acceptable?
That's fine.
Okay,
Acceptable. Okay.
clears that up.
We're going to adjourn, and we're going to come back there with a counsel from the town with a decision, and we want it in a timely fashion because of the contractual obligations that you have there with your client. Now, there's a lot of, you can see that there's a lot of stuff that has to go over because of the newness of the law and the difference there between what has been done and what hadn't been done. All right? All right? Yes, I'd like to take more. Okay. All right, a motion to adjourn then.
Motion to adjourn.
Second.
All those in favor?
Aye.
Aye.
Aye. Okay.